Hello, my name is Vinny Casiano, and I'm the founder of the Casiano Law Firm. I've been practicing in the area of elder law, estate planning, probate and trust administrations, as well as estate litigation, what some people call will and trust disputes, for over 20 years now. So not only do I draft comprehensive estate plans, but I also litigate those plans when things go wrong. Today, we're going to discuss whether or not legally you need an attorney to create an estate plan. Creating a quality estate plan that will meet your objectives is an investment. I know that there's a lot of information out there on the internet and on TV commercials trying to convince the public that you don't need an attorney to create an estate plan. So I'm here today to discuss whether or not you should hire an attorney or do it yourself. Legally, you do not need an attorney to draft your estate planning documents. Wills and trusts do not have to be prepared or even reviewed by an attorney for them to be valid. However, they must comply with legal standards and requirements. You need to decide for yourself if you feel competent to create your own estate plan, or if you instead be better by hiring an estate planning attorney. All of you probably have heard the old saying that a lawyer that represents themselves has a fool for a client. So you're going to know where I stand on this issue. When determining whether you should hire an attorney, I think you want to probably ask yourself several questions. Here are 8 topics or questions that I think you should think about when you're deciding whether or not to get an expert involved. Number 1, if you're married, do you and your spouse agree on how to pass on your joint individually owned assets, your joint or individually owned assets? Owning a mix of assets and separate property can be a complicating factor. While most people have heard of the concepts of community property and separate property, there are so many nuanced rules regarding the distinction between the two, and then what right spouses have in this property, whether it be separate or community, that without the advice of a seasoned attorney in this area, any plan devised by non-attorneys will likely not be in accordance with the law. Another common topic that is raised all the time is, do you have any minor children? Have you named guardians? And have you determined the age that your children will inherit and specify how the assets will be managed in the meantime? While naming guardians and the age is one of the factors that people should consider, I actually don't recommend that parents have a specific age in which they will turn over an inheritance to a child. There's no way that you can tell how a child will turn out when they're younger. There are certainly other ways and strategies to do this, and you can allow someone that you trust implicitly that can step in your shoes as a parent to decide what is appropriate. Do you have children from a prior marriage or current spouse or partner? I call this the Brady Bunch scenario. Understanding the various options that you have to ensure equitable distributions for your spouse and children is especially difficult with blended families. Getting advice from an experienced attorney in this regard is invaluable. Do you have a child with special needs who will require long-term care? I have been a member of the Academy of Special Needs Planners since 2005, and I have attended thousands of hours of training on how to draft quality and comprehensive estate plans for a family that has a child or a loved one with special needs. If you have a child that is receiving public benefits like SSI or Medi-Cal, what the rest of the country calls Medicaid, failure to leave a child's inheritance to a child who is receiving these means-tested public benefits will be disastrous. But just creating a special needs trust is not sufficient planning. The parents of a child with special needs trust must coordinate the rest of their estate plan, their living trust, their powers of attorney with the special needs planning. Otherwise, even the best designed special needs trust will not help. Another consideration is, how much is your estate worth? Do you have substantial assets? Do you have real property? More than multiple real properties? Do you have income producing properties? Do you have a business? Do you have lots of investments? How are they held? The bigger your estate is, the more issues that arise. A seasoned attorney can explain to you the strategies you have to minimize taxes, how to pass wealth and avoid capital gains taxes. Otherwise, passing that wealth from one generation to the other could cost you hundreds of thousands of dollars or millions, depending on your circumstance, if you do it the wrong way. The more dollars to be transferred, the greater the value of the professional guidance, both to ensure your wishes are fulfilled and to minimize the taxes. Another consideration is your plan likely to be contested? Maybe you want to disinherit a child or another heir. Failure to include very specific language when you want to disinherit anyone is essential to carrying out your objectives. There are many strategies that I provide my clients with to achieve their objectives in this regard. Doing it the right way to minimize the likelihood of a disinherited heir from contesting your plan is essential if that's what you want to do. Next, do you want to leave your estate to charity? Giving appreciated assets directly or through a trust can save thousands and thousands of dollars in taxes. Retirement plans can also provide tax savings opportunities when giving to charity. Again, this requires expert advice from not only an attorney, but sometimes from a tax professional as well. Do you own a small business or other business assets? Transferring a business to the next generation requires preparation, tax planning, and documentation. And lastly, are you concerned with long-term care planning? Traditional estate planners leave this on the side. And most estate plans that are created by traditional estate planners force you to spend all of your hard-earned money on your long-term care right at the end of your life. So if any of these topics apply to your specific family or individual circumstances, you should at least consult a knowledgeable elder law and estate planning attorney so that you can fully understand the complexities of your situations and what your options are. The problem with foreign templates, if you're doing it yourself, is that you don't know what will come back and disrupt your objectives. Know that I do speak with potential clients at no charge to better understand their unique circumstances and to explain how I can help. Feel free to text me at 619-800-6820 or email me at CasianoLawFirm1@gmail.com. I'll send you back some information on estate planning, as well as a link to click on to schedule a mutually convenient time for us to have a Zoom video consult or traditional phone call. I very much look forward to assisting you in any way I can.